Hey everybody, today is August 19, 2020. I'm on a page here called Asian American Gun Owners of California, and Stephen Wallace has asked a question. He says, everyone in this group are Second Amendment peacekeepers. I would like to pose some topics on use of force and lethal force in particular. If you find yourself in a lethal encounter, what you can, cannot, or should not do, what should you say to the cops or should not say, when do I need an attorney? Being a responsible gun owner requires you to know your limitations and rights as a gun owner. I live in Alabama. Everyone has a gun. Disclaimer, I'm not an attorney, even though I try to play one at work. Nor am I giving legal advice. Definitely do not know California law, but I'm familiar with most federal laws. Last thing I would hate to see is law-abiding citizens have to be in a lethal force incident and be jailed for defending themselves because they were not able to articulate the way they did what they did. There's no right or wrong answers here, just discussion to help you and what an investigator would be looking for investigating a lethal encounter. Cops get themselves in trouble with this also in the articulation of lethal incident. So what are the elements needed to use lethal force, whether it be firearm or any other instrument? When can you brandish your weapon to use as an intimidation tool? Fixing some of your grammar as I read. After I'm involved in a lethal force encounter, what should I say to the cops to keep from being placed in jail? So folks are chiming in here. I'm going to use this opportunity because today we have a really big fire right next to our facility. So the roads are all closed and all our classes are being postponed and rescheduled. So I got a bunch of time. All of a sudden, I'm super relaxed at home. We'll use this chance to teach a use of force class. And then this will go on YouTube, maybe Facebook, and then you guys can reference it later on down the line. So let's start. My name is Brian Wang. I teach firearm safety and self-defense classes, everything from the very beginner use of force and introductions to the concepts of self-defense, the mentality, and then as far as low-light gunfighting, force on force, precision rifle, carbine classes, anything that you think of, we do. And I used to travel a lot around the country to focus mostly on Texas, Florida, Southern California, Northern California, and lately, especially during the COVID, I've been focusing my efforts on the California Bay Area. So my business is called Monarch Defense. You can find us at monarchdefense.org. Once again, my name is Brian Wang. So let's go into it. What qualifies me to answer this question is not that I'm an expert in California law. It's not that I'm an attorney, and it's not that I'm a cop. In fact, someone who's an expert in California law actually knows very little about self-defense, because remember, the law will tell you what is illegal, the law will not tell you what is legal, and the law will not tell you what is recommended versus what is legal. So in other words, you can do things which are legal that you'll still end up in jail and you have a really hard time. And you can do things which are illegal. I'm not here to tell you to break the law, but I'm here to tell you to be educated, be smart, and do what's best for you. So in other words, understand that just because it is legal doesn't mean that we do it. Just because it's illegal doesn't necessarily mean that we don't do it. For example, when we're talking about brandishing a firearm, that is against the law. That would be typically assault with a deadly weapon, depending on where you go. So, or very similar names like that. That is against the law. That is a crime. But we can take the affirmative defense of self-defense, which is to say, yes, I understood that that's bad. I understand that we don't normally do that, but I had to because of very reasonable reasons, right? Because anybody else would have done it in my shoes. So, anyways, what does qualify me to teach you guys this is that, first of all, I have been working full-time as a self-defense firearms instructor for 8 years now. I have plenty of certifications. They don't mean much to you at this point, but what does interest you should be that comparing the certifications. So particularly this material comes from a program called Masada Ayub Group Deadly Force Instructor, which is a 5-day, 50-hour program. And that's based upon a prerequisite called Masada Ayub Group Mag 40 and Magic Masada Ayub Group Instructor Course. So those are respectively a 4-day program and then a 3-day program and then a 5-day program on top of this, just to have the basic qualifications to be able to basically explain this stuff to a very high degree of detail to you guys. But more importantly than the certifications is I work with probably 1,000 to 2,000 students per year, and now it's going on 8 years now that I've been doing this full time as a self-defense trainer. So without wasting your time on this, the point is I get lots of these questions. We have this discussion every single day. and I'm very well practiced on guiding you guys. I know what questions you ask. I know the case studies that are pertinent and recent. And I know how to take this information and tie it into, how to make it make sense for you. So plenty of people have this information. I'm not making anything up. All this information is available. You can certainly read books on this. To give you an example, in The Gravest Extreme by Masada Ayub, published 1981, I believe. That's a great book. The new one, updated version of that from, 2014, something like that, which is called Deadly Force. Masada Ayub, Massadayoob. Again, I'm here trained by that gentleman who knows a lot about this material. Is probably our nation's preeminent resource for lawful use of force. I don't claim to have all his knowledge, but I do have a lot of practice working with folks. And again, the material is very well available. It's just how many people have actually gone out and gotten qualified to teach this material. Any advice coming to you from police officers? Remember, they get, in California at least, they get about 40 hours of training on use of force. They're not training to teach you how to use of force, to do deadly force. They're training how to, apply departmental policies and their own judgment and California law and federal law in their business, their field. Now, their field is not the same as your field. It's very related. It's very similar in police law use of force, but it's not the same. The next thing is, if we look at criminal defense attorneys. Criminal defense attorneys work with criminals. They work with men who have already been arrested and accused of crimes. Their advice may not be necessarily the best for someone who's innocent, who's good and law-abiding, and who is not planning on going to jail and taking a plea bargain for a lesser conviction. So remember, we want to, if we're acting in self-defense, we're trying to not we're trying to not be arrested. We're trying to not be charged. We're trying to have charges dropped. We're trying to be acquitted. We're trying to settle for plea bargains for minor things. Not to say that we are guilty first and then try to make the best of it. So there's a big difference. And I'm generalizing here about criminal defense attorneys, but understand that criminal defense attorneys are trained how to defend guilty men. They're not trained how to teach innocent men and women before you become charged with a crime. All right, so now that was a big waste of 7 minutes, but I think it's necessary before we get into the questions. Let's go into it. What are the elements needed to use lethal force, whether it be firearm or other instrument? First of all, very good. Lethal force can be any instrument, not just a firearm. Gun, knife, stick, bat, bludgeon, rock, anything can be used to do deadly force. It doesn't have to be a gun. So you got that. Good. Next, what are the elements? Well, the elements are that you need to be reasonable first and foremost. Whatever you're doing has to be reasonable, which is to say that any normal person who doesn't have a whole lot of training would agree that, I guess in that circumstance, what you're doing is what anybody else would do, that you didn't really have much choice other than to pull out your gun and use it in self-defense. Which is to say, basically, would your neighbor have done the same thing? Would your mother have done the same thing? Would your school teacher have done the same thing? Would the local police officer have done the same thing? Would a jury of your peers have done the same thing? Would Jesus have done the same thing? That's the litmus test. That's the test really for reasonableness. If you know those bumper stickers, what would Jesus do? If Jesus would look at your situation and be like, "Gee, that's pretty tough right there. I guess you don't have much choice." That means you're acting reasonably. It's not just what you feel and what you think. It's about what would the reasonable person think and feel in your situation. All right. So moving on. So good. You're asking the right question. There are elements needed to use lethal force, and actually they're not specific to California or Alabama or any other state. They could be used in any state in the union, and they're actually going to be very similar. If you go to any English-speaking country, any Commonwealth country, you can even find majority of the stuff in any country that has Catholicism as their root culture and European colonialism. So this is very, very widespread material. We're talking not about American law, not about Alabama or California law. We're talking about English common law, which is a doctrine that predates our country, predates Jesus Christ. It predates any of the laws written down that we use today. So it is very well agreed upon. There's minor things that we could debate, but in general, this is very well understood as a cultural notion when you can and cannot kill somebody. All right, so the next thing is you're talking about deadly force or lethal force, which is good because to understand lethal force doesn't always involve in the death of the other party. but it very well could. So that has to be a fundamental assumption. For example, if you come to me and you say, Brian, I want to shoot somebody in a non-lethal manner such that they don't die, I'd say you're smoking crack. That's like saying you want to drive your car 70 miles an hour into a bridge, but you don't actually want to crash and wreck your car. Like, it doesn't happen that way. It's possible that you drive 70 miles an hour into a bridge and it doesn't wreck your car, but the likelihood of that is very low. So in other words, it would be unreasonable to shoot somebody and not expect the potential for that person to die. So we have to be willing to bring this level of force that can cause death, which basically means the reasonable person says in our society, if the bad guy brings us deadly force, we can reply with deadly force. So this is a simple rule of thumb, which is to say, if bad guys want to hurt us at a very severe level, resulting potentially death or very severe, permanent, crippling, disfiguring injuries, then we can reply with the same amount of force. So understand that if you don't die, and if you do die, actually deadly force is the same as deadly force, which is to say, let's say the bad guy brings us, easy examples, he wants to stab us with a knife. Well, stabbing you with a knife may not involve your death. That, in fact, most of them are very much survivable today, especially with good healthcare, good emergency medicine. But you have to understand that getting stabbed could potentially cause your death, could very likely cause your death. That's both low likelihood to cause your death and high probability to cause your death at the same time. One is from the medicine side and one is from the reasonableness side. All right, so understand there's kind of this contrast right there. But if the reasonable person says, yeah, man, getting stabbed is pretty bad, that's probably going to result in from serious injuries, then yes, it's deadly force. So then you can reply with, let's say, shooting our bad guy. Okay, so are there elements? Yes, you need to be reasonable. You need to understand what deadly force is. Understand that below deadly force, we have physical force or less than lethal force. Understand that law enforcement training, they subdivide this into more finer resolution for things like pepper spray and taser and verbal commands and wrestling someone and handcuffing them, or even just standing there in their uniform is a use of force in the law enforcement paradigm. But for us in the civilian world, generally speaking, we have deadly force, and then what's below deadly force, physical force, also known as less than lethal force, which is more politically correctly lately known as less lethal force. So now if we're talking about the elements, you need to show that you meet all three elements of ability, opportunity, and jeopardy. Now, different places will translate these into different synonymous terms, but they're all, the concepts are the same. So in other words, does the bad guy have the ability to hurt me? If he's got a knife, if he's got a gun, if he's got a baseball bat, that's easy. If he's got 10 friends, that's easy. What if he's 10 years old and he's skinny, but he's got a bomb strapped to his chest? Does he have the ability to hurt me? Yes. What if he's 4 years old and is a wheelchair? Oh, what if she is 4 years old and is in a wheelchair and is a quadriplegic? Well, I mean, it's pretty obvious that that person doesn't have the physical means to hurt you. So we have to look and be able to articulate how big are they, how violent are they, how armed are they, how many of them are they. And so the tricky situation is if you have two people who are the same size, same age, same physical characteristics roughly, but how do you articulate that someone is violent to the point where just the sheer violence shows you that they have a unique ability to hurt you? Or if you are the same size, same fighting ability, same ability to defend yourself, but then one person gets knocked down, or you get momentarily blinded, or you get disabled, or you're trapped in an or disadvantageous position, this would be called disparity, right? So a disparity of force. You began as more or less equal, but all of a sudden one person had a reduction in their ability to fight. Hence now you have the ability to articulate ability or means, okay? So moving on, the second factor you need to articulate is something called opportunity, which is to say they're in range, they're close enough. Now, to address this topic, you can research something called the Tueller Principle, Dennis Tueller, 1986. And basically, the Tueller principle, or the Tueller drill, is very simply translating time into distance and distance into time. If you translate that, which is to say that bad guys who are at a certain distance from you can run up there and get to you very quickly. So even though they're kind of over there still, we can articulate that they're close enough to hurt us. And if all the other elements are in place, you can use deadly force. So basically time equals distance. So do you have a room or a house or a door or your car window or just distance, open space that blocks you from the bad guy? Or does the bad guy have a gun that can shoot through those things? So you have to be able to articulate, can the bad guy get to you if they want to hurt you? For example, if you look at me, like, I'm Chinese, I got a ponytail, like I know Kung Fu, like, yeah, I'm pretty deadly, right? So if I'm deadly because I have Kung Fu, I'm just as deadly here as I am over there, as I am over there. I can cross the county line, I can cross into Canada, I'm just the same. Like, I haven't changed. My physical characteristics are not changed. Well, I fell in a skiing crash a year and a half ago and I damaged my right knee. So now I don't jump as high, I don't kick as much, and I don't do all the Kung Fu types of things as much anymore because I'm nursing a bad knee. My ability has dropped, substantially diminished. So if someone comes to me who is equally capable, equally able-bodied, but I have a disability now that they don't have, that I can articulate, hey, I have a bad knee. I don't run and fight anymore as much as to the extent that I could, a year and a half ago before my knee injury. So this is ability, but opportunity would be like saying, well, because I have a bad knee, I can't get away from someone. So therefore, under the Tueller principle, I might have, kind of had that alarm bell going on at, 21 feet. But now at maybe 28, 30 feet, I'm still saying, hey, you know what, this is too close for me because I don't move as fast as I used to move now. So I'm learning to articulate opportunity, which is how close are they? So let's give an example. A bunch of dudes are kicking down your door, but they're still on the outside. Well, can you shoot them? Technically, generally speaking, we would say no, because if they're outside, well, how do they hurt you if they're outside? Typically speaking, we would say once they breach that threshold, well, then they can hurt you because they're in your same space now. But can you articulate, well, there's 8 of them, and I can clearly identify 8 of them, and they're kicking down my door, they're impersonating the police, they're telling me the police, they're trying to open the door, they've already breached my security gate, now they're kicking down the wooden door. How much longer am I going to wait for them to actually come through? Because I can't shoot all 8 of them. Now, it's possible that I shoot the first one and then the rest of them run away, but I can't assume that I know their intentions are to flee. I don't know that. And so if I wanted to look at 8 people trying to break in, they definitely have the ability, and they're close enough to hurt me if they were to breach the door. But if they breach the door, reasonably speaking, I don't have any time to fight. I'm not able to win that fight. So what else do you expect me to do? Think about the historical context. If someone attacks your castle and you all run into your castle to hide, do you wait for them to breach your castle walls before you begin to defend yourself? Or do you defend yourself by pour boiling oil down the battlements towards them even when they're still on the outside? So we have to make a reasonable assumption here, which is that if these people come in, I may not be able to defend myself in time, even though, technically speaking, I should wait until they come in. So there's no hard and fast rule that says they must be inside your home. That's not true. Anybody who says that does not know what they're talking about. And remember, police officers, criminal defense lawyers, your friend, some dude on Facebook, these people do not have the training and certifications and qualifications to teach this material. They don't have the experience of working the what if over many, many, many case studies over years to be able to confidently answer your question and say, hey, yes, that may be typically a good rule of thumb to shoot people who are inside the house unwelcome, but that doesn't necessarily mean you can't shoot them if they're outside the house. Does that make sense? So there's a gray area which comes down to reasonableness. All right, let's move on. The third element you need to have is called jeopardy, and then you can also hear this written as intent or manifest intent or apparent intentions. Basically, what are they trying to do? Are they trying to, ask you for directions, or are they actually trying to rob you? Which one is it? You better be really clear about this, because a robbery may start as asking with questions, but maybe then they switch into the robbery. But when they're asking for questions, can you just shoot them? No. So same thing. If they're breaking into your house, are they there to bring you presents in the middle of the night on Christmas Eve? Are they there to bring you cash in exchange for your tooth in the middle of the night? Or are they there to rape, rob, and murder? All right, so if they're kicking down the door and there's 7 of them or 8 of them, and they say that they're the police, but they're not, obviously, because you can see them through the peephole, and then they're, obviously not dressed like the police, they don't talk like the police, they're not doing things the police would do, they're trying to crowbar and kick through your door, and you're debating whether or not to open fire, it's pretty clear that they're not there to do good things to you. So that's basically what we mean by jeopardy. Are you actually in danger? And how do you know? Well, their body language or their tone of voice, or the words that they say, the actions that they do. So for example, people who are trying to help you don't tend to, grab you and manhandle you and wrestle you and like physically assault you or knock you down. So for example, in Portland, we just saw this video of some people that are angry about a man who was defending some other woman who was being verbally and physically assaulted by the protesters. So if you're trying to stop this man from getting away or something like that, if you're trying to stop him from hurting someone, that's something that you could do, right? So they get him down on the ground, he's sitting on the ground, and then some guy runs up there and like kicks him in the head, and then he's knocked unconscious. Well, if you're trying to get a guy to stop hurting people, or trying to get a guy to potentially stop running people over, that's fine. That's one thing, right? But if he's already out of his car and he's already sitting on the ground and he's already being very compliant and very, cooperative, then why would you run and kick him in the head, which is an application of deadly force? In other words, that deadly force was definitely not warranted. But what is he doing? And can you articulate what this person is doing to the reasonable person such that you say, you know what, that's obvious, this person is trying to harm me, it's obvious that he can harm me, and it's obvious that he's close enough to harm me. Therefore, deadly force is warranted. Now, there's a few other best practices here, which is to say, if you can avoid it, you should avoid it. Because if you shoot somebody, boy, you're in for a lot of trouble. And even if you're legitimate, even if it's perfectly clean self-defense, that may be a very expensive and very time-consuming chapter of your life. It might be 2, 3, 4, 5 years that you won't get back, that you have to struggle through this. You might get arrested, you might spend time in jail. Expect that if you shoot somebody, our criminal justice system in the United States doesn't know who you are. And in order for the criminal justice systems to process you, they have to arrest you. That doesn't always happen, but it's a high probability that if you shoot someone, you will be arrested. Even if you brandish your firearm to display a force to prevent a shooting, that might still end up with your arrest. It's not fair. It's not nice. It's expensive. It's annoying. You get your guns taken away. I know it sucks, but that's something we have to assume may be the case. Therefore, the only time we use a gun in self-defense is if you really absolutely had to. So in other words, we're talking about this idea of imminent, meaning it's happening now, right? It's gonna happen. And the second idea is it is not avoidable. It is unavoidable. If you can drive away, you swallow your pride, you turn around, you take the insult and you drive away, you walk away, you leave, you give up whatever it is you're gonna give up, you can submit to a criminal and just walk away from it. That may be in your best interest. I'm not saying you should be a pushover or a cuck and then you should just let people pick on you, but at the same time, do what's in your best interest. And shooting someone in legitimate self-defense, but then spending the next 2 years in court and in jail and fighting this and then coming out there with, $500,000 of debt to the attorneys isn't really my idea of fun. And it's also not really your idea of being innocent, right? You may end up being innocent at the end, but you're gonna suffer through the process. All right, so, any questions on elements of use of force? Immediate, otherwise unavoidable, danger of death or grave bodily harm to the innocent, ability, opportunity, jeopardy. Good shorthand: rape, robbery, murder, mayhem, and kidnapping. To define rape: threatening violence to take forcible acts of sex. Same thing for robbery: threatening violence to take people's stuff. Same thing for kidnapping: threatening violence to take people's physical body. Next would be murder, wanting to kill someone and then killing someone. That's obvious. And then finally, mayhem. I like to use the word mayhem. It's an older term. We try not to use the word assault in my program because assault is very broad and it's very vague. In other words, you could feel assaulted on Facebook. You could be physically assaulted on the street with someone throwing their drink at you. Or you could be assaulted with a deadly weapon when someone's trying to, rob you at knife point, for example. So, or trying to run into you with your car. So all of that qualifies as assault. And so it's so broad, we don't use it. I like to use the term mayhem, which is a noun and it ties with the verb to maim. So in other words, for lack of a better term, to fuck them up really good. To disable, to cripple to the point where you're permanently unable to basically be normal. Broken arms, broken legs, gouge your eyes out, knock their teeth out against the curb, stomp someone in the head, to maim someone, to hurt them very, very severely. So if someone's going to try to hurt you very severely, threaten violence to take forcible acts of sex or your property or your physical person, or to try and kill you, you're good to use deadly force. The question then becomes burglaries. Are burglaries deadly force? Well, no, not really. They're breaking and entering your home or your business or your vehicle. But the thing is, we have an assumption. And someone here mentioned castle doctrine, which is basically what we're talking about here. It's an assumption that if they're breaking into your home, then you don't need to take the extra time to wait to find out what they're doing and why. We have a pretty good idea that they're not normal and they're not good people and they're not trying to do good things, because if they were trying to do good things, they would knock on the door. But if they're not knocking on the door, they're kicking through the door, or they're breaking in through the window, or they're just inviting themselves in through the back, that's not normal, right? And that's outside the bounds of our norms in society. And so we can therefore assume they're there to do bad things, and we can basically, as long as they meet the other requirements of ability and opportunity, we can basically shoot first, ask questions later. And so this is the idea of castle doctrine. But remember, castle doctrine only gives you an assumption about jeopardy. It only allows you to assume that they're there to do bad things, and you don't need to spend the extra time to find out. It doesn't say anybody in your house you can shoot. It is not what it says. All right. Moving on, when can you brandish your weapon? Well, when it would be reasonable to brandish your weapon. As long as you think it's worth it that you might get arrested. If you brandish your weapon, at someone who wants to pick a fight for you, can you drive away? Can you de-escalate? Can you handle it with your words? Is it really there yet that you have no other options, that the only reasonable thing you can do is pull out your weapon and threaten someone with it? If yes, go for it. But remember, there is a consequence. And depending on the politics of the time and the social atmosphere at the time, you might get arrested for it. You might get charged with a crime. It sucks. So moving on, if I'm involved in a lethal force encounter, what should I say to the cops to keep from getting placed in jail? If you are interested in learning more about this material, go to Masada Yub Group, take their MAG 40 class. Highly recommend it. But I understand it's $1,000 or $1,200 plus travel and 4 days of your time to travel around the country and meet with this gentleman named Masada Yub. But he has very good recommendations. I'm going to paraphrase a couple, so to not give away the entire program, but basically, what you're interested in is, number one, protecting yourself from the police, but at the same time, not becoming the bad guy. The third is, getting the information out there that needs to be said. So when it comes particularly to interaction with the police, they have a job to do, and they need to figure out something which is very confusing and like they don't know. They're humans. They weren't there. They didn't see everything. So they're trying to piece together evidence and eyewitness reports and ear witness testimony, either your testimony, the victim, or the perpetrator's testimony. They don't know who's who. So they try to figure out who's the victim, who's the perpetrator, who's the good guy, who's the bad guy. The problem is when you shoot somebody, normally you're the bad guy. But if you shoot somebody and you're the good guy, it really confuses folks. And they don't know exactly who's who. They can't tell if you're good or not. So you have to be first to say, hey, I'm the victim. I'm the good guy. I'm the victim. So a lot of us don't want to be victims. Understand, you must be the victim if you are going to be the good guy. If you're not the victim, you cannot be the good guy if you're the victim of crime. Or you have to be able to articulate that someone else is the victim and you are defending someone else. If you do not claim responsibility and ownership over the victim status, then you end up being the bad guy, the perpetrator, and then you end up going to jail. It is what that is. Because remember, this is a system that's built for handling criminals, and we are an exception to the rule. Shooting someone in self-defense is, generally speaking, is pretty rare, relative to how many crimes, how many bad guys shoot good guys. If a good guy shoots a bad guy, it is an exception to the rule. So you have to be willing to say, hey, wait a minute, I'm the victim. He did X, Y, and Z, and in response, I shot him. So you're not just calling the police saying, hey, I shot somebody. That's not what you want to say. You want to be able to say, look, I'm the victim. This is what happened. Lay out what we call the active dynamic. What actually happened to bring you to the point that your reaction was reasonable, that you had no choice but to use deadly force in self-defense. All right, so that's first. Second of all is make sure that you're able to point out key evidence and witnesses, because if you don't point it out, who's going to point it out for you? If nobody else was there, you're the only person who was there other than the person who's deceased. Like in the George Zimmerman case, if you don't point out evidence, who's going to point out the evidence? The blood on the back of his head in the George Zimmerman case, once he washes that off and the wounds heal, by the time you go to court, a year later, there's no more wounds and there's no more blood. So you have to point that out and get that documented right away on photograph and in your testimony. Hey, look, he beat me against the sidewalk. This is the blood on the back of my head. This is the blood stain on the sidewalk. You must document that, because if you don't document that, who will? So this is called pointing out key evidence and witnesses. And then to paraphrase respectfully, hold off and just like allow things to calm and settle, allow kind of everything to kind of run its course a little bit. Find your lawyer, start getting ready. If you need to go to jail, start getting ready with your bond or your bail or your own recognizance at your first hearing. And then at the point you're looking for the long game. Remember, this is a marathon. This is not something that happens overnight. you know, if you actually do shoot someone, it's possible that you're totally clean. Cop shows up, they're like, okay, you're obviously the good guy, that's obviously the bad guy, good guy shot bad guy was doing bad things, all good. But it's quite possible also that the cops will look at this and say, well, shit, bad guy's bad and you're also bad and he's also bad and I don't know what you were doing, and you call that self-defense, and this is gonna need more time to sort it out, and everybody goes to jail. So anyways, understand that this is a last resort tool. Understand that you may face legal consequences, but if you are innocent, use your innocence and use the truth to protect you, which means that you're going to have to speak up and say, hey, look, this is what happened and this is who I am and I'd be willing to cooperate. So protect yourself, but at the same time, you don't really want to be saying things like, I want my lawyer, give me my lawyer, right? Because you spit at the cop's face like that, you're going to end up, you know, looking like the bad guy, right? So we have to, you know, kind of understand that they have a stressful and tiring and dangerous job, and be able to work with them, and so they can kind of sit down and figure things out. Okay, so here we have some advice in the chat field, basically telling people to shut up and not say anything. But remember, that can also work against you. What you can say can of course be used against you, but what you don't say can also be used against you. So understand that there's a fine line there. All right, we talked over use of force, deadly force, ability, opportunity, jeopardy, otherwise unavoidable, death, great bodily harm. You can defend the innocent, so I want to bring that out there. Yes, you can defend others. So, and again, this stuff is best practice, and this not necessarily state law, and it's pretty much applicable to anywhere in the country. Although you're going to have minor differences locally here and there with state laws and with what's reasonable to the local population. So again, if you're in Texas, you know, shooting someone on your front porch may be seen differently, culturally speaking, compared to if you're in New Jersey, right? So different places, different culture on this idea. But for the most part, it's not that complicated once you have someone to break it down for you step by step by step. Now, there's many other what ifs, and I went through this very fast because I respect your time. But understand, you know, this is like 2 weeks of certifications to be able to bring this material to you in a half hour. If you're in California, the Bay Area, check out monarchdefense.org. You can find me on Facebook, Monarch Defense, Instagram, Monarch Defense, YouTube, Brian Wang. My YouTube's not great, but it's there. I used to do a lot of classes in Texas and Florida. Those will open up back up maybe in the fall or winter. But for now, a lot of classes in the Bay Area, in the San Francisco area. So if you're local, come stop by, see us for a class. It could be beginner classes, advanced classes, night classes, force on force classes, carbine, shotgun, pistol, rifle, whatever. You want to bring kids over, we do kids day. You want to do long range precision, that's totally fine as well. We do lots of that. So if you have questions, write them in the chat box, and I'll talk to you all soon. Take care.